SJC-11566, Commonwealth v. David, St. Hilaire.
Good morning.
Good morning.
Please, Court. Stephen Rappaport for David St. Hilaire. For hundreds of years, I would submit, rescission has been the remedy where undue influence is proven in a situation such as this. This is a case that there's no question the court found, the trial court found that Ms. McGill lacked the capacity to properly contract, that the defendant knew or should have known that she lacked the capacity to contract. There was, however, in this case, no fiduciary relationship between the parties. There was no, I would submit, unjust enrichment in this case, and I would also submit that there was, at least prospectively, fair consideration in this case. And while the court certainly made findings with regard to the capacity of Ms. McGill and the defendant's knowledge of that lack of capacity, the court also made findings, I would submit, in finding the defendant not guilty of larceny by false pretenses, that there was no fraud in this particular case. As the court reasoned in a number of situations, the consideration to Ms. McGill, certainly in the condition she was in at the time, may have actually been quite fair. Number one, putting aside, I would submit that the Commonwealth never proved what the value of the property was in this particular case. What the consideration was in exchange for the property, St. Hilaire provided two mortgages, value of which was approximately $800 a month to be paid to.
Sign those mortgages, did she?
No.
Nor the prospective benefit you talked about, the life estate, that she didn't sign that either?
No, she didn't.
But and didn't the
However,
mortgages?
the court made finding. I would submit that certainly at this point, we're not trying to make factual findings. The court made factual findings in this case that, in fact, this was the consideration provided to her in this particular deal, and that was the reason why there was a not guilty on the false pretenses.
I thought that had to do with the fact that she didn't have the capacity to appreciate that something false was being said to her, because she had no capacity to
I would
understand.
submit, Your Honor, that in this particular case, the judge thought out loud on a number of occasions and actually stated that prospectively, for a person who suddenly had taken a turn for the worse and might be physically incapacitated as well, this was not a bad deal at all. He flat out said that the value of the property never having been established by the Commonwealth, the mortgages may have been $92,000 plus paying off the liens, a total of $100,000 for something that was assessed at $128,000 may have been fair.
But is it true that the mortgages basically ended on her death?
Yes.
So that would mean, I take it, if the mortgage was for $50,000 and she died the next day, your client would owe nothing, would have
That's
the
what happened
property
in
and
this-
owe.
Actually, that's what
Right.
happened in this case.
So doesn't that come into the calculus about whether it's fair consideration?
It does, but if we were sitting here 3 years or 4 years or 5 years after.
I know, but wasn't this all negotiated at a point when she was not well?
Well.
And I don't mean well in terms of her mental capacity. I meant physically well.
My sense is that until July 13th of 2010, she wasn't physically incapacitated at all. That's when she fell and broke her hip. She is in the hospital on July 13th.
When was this purported to have been arranged?
Well, according to the defendant in his statement to the police, it was originally contemplated in May or June, before she had fallen and broken her hip.
But she had refused to enter into the deal several times, and this didn't actually happen until she was incapacitated.
And that's what the judge reasoned, that because she had a changed circumstance, suddenly this does look like a very, very good deal.
Good deal for
For her.
For him.
a life estate?
Certainly it's a good deal for her. If she's going to be incapacitated and he's going to provide her with a place to live for the rest of her life, as well as provide her with money, as well as
I don't
pay off
remember the
liens.
details. How old was Miss?
She was in her mid-80s.
Okay, and so
86.
the life estate was maybe not such a big thing, right?
There's no question that he took advantage of her.
So we're
There's
really
no
just
question.
focused on whether, not all, whether this statute governs this
Well,
scenario, right? That's the concern, isn't it?
That is one of the concerns, but one of the concerns that I would submit I have in this case as well is the question as to whether or not, while the court found a trespassorial taking, whether or not there was an intent to deprive her of the use of the property permanently. And based upon the life estate, I would submit that that element of the offense was never established.
But
Looking at it-
doesn't permanently include, maybe, that life estate, but also that you're going to have the value of the property as part of your estate, which she wasn't because the mortgage expired at her death.
Well, but she was going to have the use of the property.
But she wouldn't,
Well, that's what, if you look at 27739, 27739 talks about permanently depriving somebody of the use of their property. I'd submit that's the common law, that if you don't have the intent to deprive somebody of the use of their property, then you haven't committed larceny. Certainly you haven't committed the crime of larceny. It's interesting in this case that in relying upon cases from other jurisdictions, the judge seemed to recognize that, well, the facts aren't really the same in these other cases, nor are the statutes the same. The facts in the cases that the judge relied upon, there was no consideration. It was purely and simply the plundering of the assets of people who had, if not fiduciary relationships, fiduciary-type relationships with the people that were plundering their property. There was absolutely no consideration. They were gifting as opposed to sale scenarios. Now, I know that as the court below had a problem with it, and as this court seems to be having a problem with it, that it looks like it was a scam from the beginning.
you wouldn't disagree that if instead of this, basically, Mr. St. Hilaire had gotten the owner of the property to sign a new will in which she gave over the property to him, that there wouldn't be a very strong case of undue influence?
Well, we actually have that in this case, Judge. As I say, she was brought to the hospital on, I believe it was July 13th. On July 13th, while she has an IV of some painkiller in her arm, the daughter of the person who originally was supposed to inherit the property brings an attorney.
Miel, or is that?
Mealy. Mealy brings Attorney Donahue to the hospital, and a codicil to the will is executed at that point. It's very interesting because if you take a look at the documents that were executed by Ms. McGill earlier in her life, you see a handwriting that's, at least it's a distinct handwriting. I'm not saying I'm a handwriting expert, but when you take a look at the McGill signature on the document provided by Mr. St. Hilaire and on the codicil to the will, it's a very, very different type of handwriting. What I submit to you at this point is, if Ms. McGill was found to be incompetent on the 17th, and of course,
Which the the status exam said she,
The status exam, right, which the court accepted, and the court had every right to accept. You mean to say 4 days earlier, when she's got the IV of morphine in her arm, she's any more competent? That's why, frankly, when
We're
it
kind
came
of
time for
revisiting some
sentencing.
facts, but can I just interrupt you, because you didn't really raise the argument of that he was depriving her of the use of the property below. That's what you're arguing here, and it becomes, I mean, I guess you could have argued it below and talked about the fact that she shouldn't have or couldn't have given her interest or bequeathed her interest to somebody else, but that's what happened. Those are the facts here. They're not subject of concern. They weren't the subject of concern in the trial court. At this point, you just deprived, if the individual deprived her of the property and because she wanted to give it to somebody else, that's a deprivation, use or not. She didn't personally have to use it, does she? I mean, you didn't argue that below. I'm not sure that that's correct.
As I understand it, if the court accepted the fact that a life estate was granted to her, then I submit to this court that it was never established below that there was an intent to deprive her of the use of property permanently.
But by that reasoning, if you take $1 million from somebody at the end of their life and say, you can spend whatever you can during your last days, then it's not larceny.
No, because there'd be no consideration in that particular situation.
Well, the cons-
Here,
but-
there,
but-
here
but-
there
but-
was, Your Honor,
Okay, but the
there was-
consideration goes to the issue only of whether it was with consent, does it not?
I submit no.
Well, let me give you this example. Let's assume a person drugs a woman who has a quite lovely ring. When she's unconscious, he takes the ring off her. The ring, let's say, is worth $10,000. Let's assume he puts $10,000 in her pocket and walks away with that ring. Is that larceny? She's not consented to the taking of the ring,
Well,
but
I would submit
but you've
that the
given her the
distinction
fair
there-
market value.
The distinction there, Your Honor, is that he does intend to deprive her of the ring permanently, as opposed to here, where in addition to leaving the $10,000 for the ring, he says, and I'm going to let you have this ring and wear this ring for the rest of your life. That would be the situation
that
more
would be-
analogous, and I would submit in that situation,
Even if
perhaps
she
that's
doesn't
not
want to do
larceny.
that?
Excuse me?
Even if she doesn't want to do that? No, I don't want to do that. I don't want to do that.
Well-
I want to have this because I want it to go to my granddaughter.
You know-
Forget it. I don't want the money. I want my ring. And if she were competent, that's what she would have said here, let's assume. How can that not, under that scenario, how could that be okay?
Well, this one, I'm going to use the reasoning that the trial judge used in this particular case, and his reasoning was, look, she may have said, I'm not going to sell him this property, I'm not going to sell him this property, I'm not going to sell him this property. Now suddenly, she's in the hospital, she realizes that she's not going to have the mobility that she's always had, that her life may change in some way, she could use the additional cash, and he's going to provide her with the place to live and the upkeep of that property, and he paid off the municipal lien so
Where's
that
the
she'll...
point at which she understands that and appreciates that and says, yeah, that's what I want to do it?
She never appreciated it.
Okay.
Without a doubt.
All right.
I
So we're
accept the
talking-
court's finding that she lacked the capacity to understand
Didn't
what was going on.
undergo all that thought process to get to this point, as far as I mean, I don't see that.
Well, I'm going to accept factually what the court found, that yes, she
Good
lacked the
idea.
capacity, A, and B, St. Hilaire knew she lacked the capacity and took advantage of her.
Okay.
Did he define knew or reasonably should have known?
Well, whether he knew or reasonably should have known, and that's what the court found, that he knew or reasonably should have known. And there's no dispute, that's a factual finding. That's not a legal finding, that's a factual finding. So I would submit you have the first two elements of the offense of larceny. It's the third element of the offense, and that's the intent to deprive her of the property permanently. When he sets up, as part of the consideration, a life estate, and the Commonwealth never disproved that there was adequate consideration in this case.
But the point that we were discussing is, if I say, thanks, I don't want the money, I want the ring so I can give it to my granddaughter when I'm dead, that part didn't happen. So it was a deprivation.
Here's the problem with that reasoning, Your Honor.
Couldn't make that.
Here's the problem with that reasoning. We know that 10 years earlier, she wanted the property to go to somebody else at her death. Now, she's in the hospital, as I say, having no more capacity necessarily on the 13th when she's has.
We don't know that.
Well, we don't know, but we do know that 3 days later, she's not competent. We know that she had broken her hip that day. She must have been in
She didn't
incredible
have the
pain.
capacity for that moment, and that wasn't at issue here.
Well, I'm just saying, when the government was looking to provide an opportunity for victims to come forward and give their victim impact statement, the judge cut the government off right away and said, whoa, there's only one victim in this case, and that's Ms. McGill, the person who was supposed to then inherit. The judge didn't view that person as a victim at all, and in fact, I would submit the judge would have been just as likely to say, that should be rescinded as well as
She
this.
called her lawyer, had her lawyer come before she had the surgery. Anyway, I think those are
well,
facts a little bit
and-
beyond the scope of this interesting issue.
I do want to state.
I'm afraid your time is up, but if you have one more point, I'll hear it.
Well, it's just that fair notice is an important factor in this particular case. If it took the judge such a difficult time to try to come up with whether or not this was larceny or not larceny under these particular circumstances, I would say that a layman would have a much more difficult time in trying to decide. And if you look at even back to McBoyle, where Justice Holmes says, well, it's not likely that a potential thief or murderer is going to go contact a lawyer and try to check out the landscape. Well, in this case, it seems that that's exactly what Mr. St. Hilaire did. And I would submit that there was no fair notice that this was a crime based upon the fact there's never been a case in the Commonwealth like it. And on that basis, I would submit that the conviction should be reversed.
Thank you.
Thank you, counsel.
May it please the court, my name is Melissa Johnson. I'm an assistant DA in Middlesex County. Here with me at council table is David Sollett. He was the trial prosecutor in this case. I'd like to start with the idea of consideration that was talked, which my brother discussed, and whether this was quote unquote a fair deal. First of all, there was no finding by this trial judge that this was in fact a fair deal. And with good reason, because ultimately, the trial judge found that this was larceny by stealing, not larceny by false pretense. And there's a subtle difference there. With larceny by false pretense, there is consent. There's an understanding by the victim owner that, in fact, that victim is transferring his or her property to the defendant. That consent, however, is obtained by some kind of fraud or misrepresentation, or so implied by the circumstances. With larceny by stealing, which is what the trial judge found here, there's no consent. There's an absence of consent. And in our case, we submit it's an absence of valid consent because she simply didn't have the capacity to do so. So in terms of the particulars of this quote unquote deal, whether it was fair, whether it was, as we submit completely lopsided, it doesn't matter, because at the end of the day, she just did not understand the fundamental notion that her property was being transferred from herself to the defendant when she signed that deed. And that is why all of this discussion about whether the life estate, the mortgages, what their value was, at the end of the day, it doesn't matter. I'm happy to go into the fact, yes.
But let me ask you this, though. Is there a risk that what would be either undue influence, or you could undo a contract because of lack of capacity or whatever, that we are suddenly making every single one of those a criminal act?
Absolutely not, Your Honor. And it's interesting that you asked that, because here we are, larceny has been around for centuries, as we know, in this jurisdiction. Here we are in 2014, finally discussing the issue of criminal intent with respect to lack of capacity. So I don't think that all of a sudden the floodgates are going to open. I think a jury that is properly instructed that if a victim, an owner victim, if they're properly instructed that that person is so mentally impaired that they're not able to understand the fundamental notion that their property is now going from themselves to another person, to the defendant. And more than that, the Commonwealth has to prove beyond a reasonable doubt that the defendant knew or should have known about that lack of capacity. Only then is that a criminal act. Only then.
Let me give you this hypothetical. I gave one to your brother, so let me give you one. An individual, let's use the same ring. A person gives $10,000 to the woman who appears to be intoxicated, takes the ring. Woman claims, I did not consent. Judge finds that she actually did not consent to it, but that the clueless individual actually did not, in good faith, did not understand that she did not consent. He actually, in good faith, thought she had consented. Is he guilty of larceny?
In that case, it looks like we have proven the first step of that she had an inability to consent, but we would still have to prove that he knew or should have known.
Well, it's the should have known part. Isn't larceny a specific intent crime?
Well, should have known, so it's more like an honest or reasonable mistake, I suppose, in that case.
Well, if it's a specific intent crime, it's not only should have known, did know, right?
True. Now, it's kind of like the honest mistake or isn't a reasonable mistake with that kind of affirmative defense. But at the end of the day, the defendant is going to always claim in that case, well, I thought she
Well,
would
the
have
claim may be
ability.
discounted as not credible in the circumstances.
True.
But
There has to be some kind of objective standard that the jury can look at.
no, there doesn't. Why does there have to be an objective standard if it's a specific intent crime?
Because the defendant is always going to say,
Well, he
But
can say
say,
whatever he
yeah.
wants, but it can be disbelieved because the circumstances are so unreasonable a juror wouldn't believe it. But that's a little different concept.
so at the end of the day, the result is the same. He's guilty.
Well,
So-
But you have to
the problem
prove.
you have here is, let me read to you on page 7 of the record appendix what Judge Kaplan instructed himself. That the second element was that at that time the defendant knew or reasonably should have known that Ms. McGill was that incapable of understanding the transaction that the defendant was asking her to enter into. So if you're wrong, and if the specific intent requires that he actually knew, don't you have a problem?
I don't think I have a problem in this case at all. Any trier of fact would see from her appearance that it was readily apparent that she was mentally incapable of entering into this transaction. We have medical personnel. We have the roommate that is in the room with her, the fact that she failed a mental status exam.
Well, how do we know that Judge Kaplan made that finding where he specifically said that the findings that he made is that he knew or reasonably should have known? Or that was, let me see how he described this. He described the court has instructed itself. So he's basically instructing himself as to the elements of the crime, and he finds him guilty based on this second element that he knew or reasonably should have known. But we don't have a finding. You may be correct that on remand, the judge may say, no, I think he knew. But how do we manage to affirm without a remand?
Because there is enough evidence in the record that this judge completely disbelieved the defendant and his story. The defendant's story was simply not credible in any way, shape, or form.
Did he say that?
He does not specifically say that, but it is obvious from the way that he has found the facts in this case that he doesn't believe the defendant's story at all. And in fact, I did have the DVD of the defendant's interview before with Detective Hultgren transferred to this court so that your honors could see for yourself why this judge would have found the defendant's story completely incredible in this case. He completely concocted
why should we infer what Judge Kaplan would have found, as opposed to saying Judge Kaplan erred in saying that reasonably should have known is sufficient, and say, we remanded to Judge Kaplan, it's a bench trial, you have to find either whether or not he knew. And if he found he knew, he's guilty. If you find that he only did not know, but that he made a good faith, honest mistake, then he's not guilty.
There is more than enough evidence here, and this is a required finding.
Sufficiency, it isn't a sufficiency question, is it? I mean, it's really, what did the judge find?
It is what the judge found, yes, but all of these inferences are taken in favor of the Commonwealth. And we have a situation here where this defendant knew that this woman had an attorney, knew who the attorney was, knew that that attorney recommended that she not engage in this transaction with the defendant. And he takes the one opportunity when she has no one in that room to protect her, with one opportunity.
We're not suggesting it's a failure of proof. We're not suggesting it's a failure of proof. We're suggesting that perhaps the judge has misinstructed himself or the jury so that we are uncertain as to whether he made the sufficient findings.
Well, with all due respect, I disagree with that. I think that the trial judge here did an excellent job as far as instructing himself in the law, defining what the law was in an area where there isn't much here in this jurisdiction, in this unique situation here, defining what larceny was, defining that the fact that consent or lack of consent can be proven beyond a reasonable doubt by the victim's lack of mental capacity. And he clearly defined that and instructed himself on the elements, taking that in consideration, incorporating all of the jurisdictions that have decided this issue, all of which have both a subjective and an objective standard that they look to as far as determining whether the defendants had the criminal intent here. There's no jurisdiction that I have found that simply has a subjective intent or subjective standard for this. And the judge took all of those cases and he formulated an instruction that was fair and that was just and that comported with the law of larceny. And so for that reason, Your Honors, the judge did a fantastic job here as far as recognizing what the law should be in this unique area. If there are any questions about that, I simply want to quickly address my brother's argument as to the permanent, whether he deprived the victim permanently of the use of that. I will just mention that my brother cites a statute, 277, Section 39, which talks about how indictments are worded and the words in those indictments are defined. There is case law out there, which I've cited in my brief, Hildreth and specifically, which talks about the fact that that does not actually define the elements of the crime. That has nothing to do with defining the elements of the crime. The elements of larceny have always been with intent to deprive the person permanently. There's never been the idea of use of a property permanently. That has been the law of this land for years. Besides the fact, we are talking about a required finding standard here. So if we want to even take that language for what it is, the fact of the matter is, as soon as the victim signed this deed, he changed the locks on that property, he went and recorded the deed, and as far as we're talking about a life estate here, there's absolutely no evidence that that life estate actually even existed or was enforceable. The only person that seems to know anything about the life estate is the defendant himself. It was drawn up by the defendant. It was never signed by the victim. It was never left with the victim. It was never recorded with the deed as one would expect an infringement on the title to be recorded. So the reasonable inference is that this was simply concocted by the defendant, as I said before, to create some kind of veil of legitimacy over this transaction. So again, talking about the required finding standard, there's no question here of his intent to deprive her permanently, whether it be the use of permanently or just permanently, which is the law of this land, of her only asset, which was her home.
Did the defendant present as evidence at the trial the written life estate?
What he did was he gave a copy of what he had purported to have drawn up to the detective, and that was admitted in evidence. It's actually in my supplemental record appendix. You can
Had
see
he
for
signed
yourself.
it? I just don't remember. Had he signed that?
I don't believe he had, but I could be wrong on that. I do know that she did not sign
I
it.
understand that, but it's, at that point, it's him giving the life estate, so I'm just thinking it would be he that would have needed to
If you
sign
could
it.
just give me 1 second here, I can check. If he did sign it, he did sign it, yes.
And did it correspond to the date of the deed?
No, it was July 1st, Your Honor, and the deed was signed, I believe, July 26th.
The life estate was
Dated that
created
with-
before the deed?
Assuming that it's actually
Right.
valid or
Was actu-
genuine.
Yeah, whether the date was or wasn't
Right.
inserted on that, that wasn't in
He
evidence.
put down that date. But the deed was actually signed and recorded on July 26th. But there's nothing here, and it's in my supplemental record appendix at page 20, if you'd like to see it. There's no evidence that Erica McGill ever even saw this document or was aware of this document. So as with the mortgages, again, not signed by Erica, neither of them were signed by Erica, and the value of them was next to nothing. We're talking about they're dischargeable upon an 86-year-old woman's death, a woman who is gravely ill at the time that these were purportedly drafted. If there are any further questions, I would rest the remainder of my argument on my brief. Thank you very much.
Thank you, counsel.